Welcome to NACD BoardVision, where leading boardroom advisors, governance professionals, and seasoned directors discuss critical issues related to your responsibilities in the boardroom.
I'm Chris Clark, publisher of NACD Directorship magazine, and this is BoardVision. Today I have the pleasure of speaking with Joe Yaffe of Skadden on the important subject of compensation. Welcome, Joe.
Thanks, Chris.
As far as I know, the proxy season is over for most companies. I read your most recent report. You co-authored it. And I didn't see anything dramatic, but I'm sure I may have missed something. So I'd really like your interpretation.
Sure. So you're right, the proxy season is over for the vast majority of issuers in the country. And there were a couple of headline items that came out of the 2013 proxy season from our point of view. The first is that there was more of the same. And by that I mean we settled into our third year of say on pay. People are now accustomed to it and used to it. But most importantly, in terms of the statistics that came out of the 2013 say on pay numbers, what we observed were basically the same voting patterns as we had in 2012. And I think that that was good news for a lot of issuers, many of whom are simply looking for certainty as they head into 2014 and future years, with an eye towards understanding exactly how their shareholder base will be reacting to say-on-pay proposals in light of their internal compensation structures. We did observe a new phenomenon that was discomforting to a large number of companies, and that is a wave of proxy-related litigation that arose first at the beginning of the 2013 proxy season and really picked up speed as we went through. And what these cases centered on were primarily disclosure issues relating to proposals to increase the number of shares under company equity plans, or in some circumstances proposals to increase the number of authorized shares for the company. What we also observed is because as the proxy season went along, issuers got the benefit of observing these claims as they were being made. We saw changes in disclosure practices relating to equity plan disclosure as well as disclosure relating to authorized share increases. And much of that disclosure was intended to head this litigation off at the pass.
Let's go back to me asking you to look into your crystal ball into 2014. And obviously I just read in the Wall Street Journal that, and the SEC has been threatening this for years, that they're finally going to set forth guidelines or laws concerning CEO pay and clawbacks. And so when this comes to fruition relatively shortly, how can boards and directors really think about it and, if anything, be proactive?
We're expecting final rulemaking out of the SEC on internal pay equity disclosure rules, and those would be rules which we think in their final form will require disclosure comparing CEO pay to the median pay delivered to all other employees in the company. On the clawback side of things, we're still likewise expecting final rulemaking out of the SEC. Have not heard the same messaging that final rules or proposed rules are imminent, but we do expect them to get them eventually as part of implementing the requirements under the Dodd-Frank Act. And so we will have mandatory clawback provisions enforced and enforceable across the country for issuers sometime in the future. But in the short term, I think it's the internal pay equity disclosure that companies will be focusing more on in 2014.
Well, I'm not going to go away from a highly charged subject. I'm going to talk to you, or I'd like to talk to you about director pay, and certainly outside the boardroom, it's a point of attack. Is there any inoculation that a board can prescribe to themselves on that subject? And there may not be, but I'd love to hear your opinion.
Well, nobody has a silver bullet, but the best inoculation is attention to detail and careful diligence. What we've observed is that director compensation historically has not been a hot button issue for institutional shareholder services and other proxy watchdog groups, nor has it been a hot button issue for the majority of shareholder activists that are out there. What we're seeing now is, the result of years and years of increased disclosure obligations by public companies. And in some respects, that's been a good thing. Shareholders certainly have much more information now about the compensation delivery and absolute metrics of compensation being delivered to executives than they have at any other time before. On the other hand, the average proxy now is weighted down with such significant and complex disclosure that it's becoming very important for the companies that we deal with, and compensation committee members especially, to pay close attention to the disclosure, to make sure that the messaging that's coming through is exactly the messaging that is appropriate and relevant and necessary for shareholders to properly consider the compensation that's being delivered.
On behalf of Skadden, Joe Yaffe, and NACD, thank you. This is BoardVision.